Good morning, everyone. Welcome to this morning's Knowledge Bank. Today's webinar is being presented by Dorian Lawrence, Managing Director from FR Consultants, and he is going to be speaking to you about fire safety legislation, amongst other things. There will be questions taken throughout, so if you want to submit your questions, Dorian will be answering them at the end of each chapter of the presentation. You can submit them in the Q&A box, which is at the bottom of your screen. The webinar is also being recorded today and will be available to watch back later for anyone who cannot join live. And if anyone would like a copy of the presentation, please let us know and we can also arrange that for you. I am now going to hand you over to Dorian to begin the presentation.
Thank you. Good morning, everyone. I'm Dorian Lawrence. I'm a chartered building surveyor and chartered building engineer with a wealth of experience in the fire safety, construction, design, management, compliance sector. We as a company have been tracking the changes in legislation since the Grenfell fire, looking at previous to that, how weak regulations and compliance was and how poorly enforced it was, and also then moving through to tracking all of the new legislation. Now, there's a lot to get through in this presentation. I make no apologies for that because it is quite complicated. So if you're an RTM or an RMC, if you've got questions, please raise those questions at the end of each chapter as we get through it. You'll see in a moment on the agenda, it's broken down into 3 pretty clear chapters. But please do think of everything and anything that you want to ask. If we can't get through all of your questions, or you think of something after, if you drop us an email on inquiries@frconsultants.co.uk, we will come back to you. So, like I say, quite a lot to get through, and we'll get as many questions from you as you can. Even if you think it's not that relevant, please ask it, because sometimes it leads on to some other discussions. At the end of the presentation, there'll be a QR code. We always ask for a Google review where possible. So if you could please give us a review, that would be fantastic. So we're the UK's leading fire safety and facade experts, and we have a complete end-to-end process. So having tracked all of the old legislation and looked at the new legislation, it's really key to understand what you've got to do. So from the initial report, understanding what's wrong with the building, externally and internally, and we'll talk about internal issues as we work our way through. Then to designing and looking at compliance and how we're going to make that building compliant, and then how are we going to work with the new legislation of the Building Safety Act to make sure that the building is compliant, safe, saleable, mortgageable and insurable. And lots of consultants forget about the saleable element, getting a mortgage and insuring it. We're acts as facade advisors and fire safety advisors, and we look at the insurance industry and see what problems that there are. Seeing some policies have gone up to 7,000% due to a lot of these issues. Brief introduction into the business. We're part of the RSK group, and that's a group of 230 or so consultants to which we have access to them all. We are part of the Property Institute and are registered with the Chartered Institute of Buildings, CIOB, who develops the Building Safety Act qualifications, and chartered with the Chartered Association of Building Engineers. Professional indemnity insurance in the sector has been a massive issue. It gives you a bit of confidence in us that we've got £10 million covering all of the fire safety aspects. So quite difficult to get those policies, but because we've got the right staff with the right qualifications, the correct ISO accreditations, and also all of our staff fully trained in each sector. So we have a team of building surveyors, quantity surveyors, fire engineers, designers, clerk of works, project managers, and so on, to make sure that we can cover all bases. All of those staff are employed, so they're all under our control. Lots of different clients, lots of freeholders, managing agents, lots of RTMs and RMCs, trying to help protect them with regards to issues, one, with the new legislation, but also when it comes to developers and how perhaps they're trying to take shortcuts because it's quite costly for them to remediate. So involved in lots of interesting cases, helping the RMCs and RTMs, making sure that they are compliant and that the developer is doing what they should be doing. We're proud to have joined the MHCLG professional support team for the auditing of EWS1 forms, so we're on that panel. And we're also a key member of the Cladding Safety Scheme Assessors Panel. Don't just work in residential, because we find that these days many buildings have various different uses. So we might have a block of flats with a car park above, we might have offices, as well as the block of flats, shopping centres. We've got several that we're looking at and working on where they have residential included within the shopping centre. We run a full testing facility, so if products need to be tested to check that they're compliant. And then the legal side, a lot of our customers ask, right, what do I do? Where am I legally liable for this, or who is liable for it? And then we pass all of our legal work over to Blake Morgan. I sit on the consultants as the consultants representative on the government expert panel, giving advice on the industry and what's happening, what the issues are, what the bottlenecks are, what the problems are. And we also sit on the Cladding Works on-site project engagement forum, which looks at resource in the industry, which is quite interesting because as more and more buildings come to light and more requirements come in to comply with the legislation, it becomes a more difficult arena to be in. So quite interesting to look at. Government thought it was a 18-month, 2-year problem. I think it's more like a 20-year problem, is my advice. So we're going to look at the Fire Safety Act, how that works, and also how you do a report in accordance with the correct standard, which is called a PAS 9980. We're going to have questions at the end of that, so please think of anything on the Fire Safety Act as we work our way through. And I can hopefully answer those. Like I said, if I can't answer them, we will come back to you via email. Fire Safety England regulations, a new section of regulations that came in on the 23rd of January 23. So quite caught a lot of people out, that section, but we'll have a quick look at that. So again, very short section on there. Think about any questions for there. Then the Building Safety Act, biggest change in regulations in a generation and how we comply to that. We've got about 60 or so slides to go through, a lot of information. I believe you can get the recordings from News on the Block from Vicky afterwards. So it shouldn't be an issue. So you can go back and listen to it, refer to them. We do change this presentation as future issues happen, as legislation may get tweaked or changed. We do amend this presentation. So in 6 months' time, if you're referring to it, you might want to drop us an email and check something out just to make sure it is current. So the Fire Safety Act 2021, the Fire Safety Act was introduced on the 19th of March 2020, came into full force on the 16th of May 2022. And the Fire Safety Act is the first legislative step in the process of implementing the recommendations from the Grenfell Tower inquiry. Broken down into 4 simple sections, and we're going to work our way through those sections. They're fairly straightforward. So, section 1, and this covers all multi-occupier buildings of any height in England and Wales must have a fire risk assessment which takes into account the external wall via an FRAEW, and that's a fire risk appraisal of the external wall. Now, when we conduct one of those surveys, we must look at the complete structure of every wall type. So not just the cladding, the insulation, the internal skin, what is happening in that wall with regards to cavity barriers and so on. We have to look at all of the attachments on the building, so not just the balconies there. You might have air conditioning units, you might have car chargers, and so on. So we have to look at all of those. We also look at doors and windows within the external wall to see what construction they are. But also under the Fire Safety Act, we must undertake a fire door survey of all the communal doors, but also consider all the doors into the apartments. And you may have listened to some of the Grenfell Inquiry, quite interesting podcasts on that with regards to the fire doors into the apartments, that they were defective and they were supposed to be 60-minute doors, and when tested actually lasted for 20 minutes. So we have to look at the doors into the apartments. So we gather lots of data under section 1, but don't forget that is buildings of all heights. It is not just buildings over 18 metres or 11 metres. We will work our way through those height classifications and how they apply to other legislation. Section 2 is the power to change the premises to which the fire safety order applies. England, that is the Secretary of State, and in Wales, it's the Welsh ministers. Can't see any changes coming to that at the moment, so all should be fine. Section 3 is talks about the risk-based guidance, and we're going to look at that risk-based guidance and how we deal with that and the quality of the report. So we see, and we audit lots of reports for the government funding scheme, but also for lots of freeholders that have had a report that don't think it's quite up to standard. Now, there is a set method and a way to do the reports, which we will look at in just a moment. However, when we look at how liable you are, if you're an RMC and an RTM, you are the accountable person, so you're liable for the quality of the report. So it's essential that you choose someone that can undertake that report to the correct standard. If you don't, you could be held liable if the report isn't up to the correct standard. So section 4 covers commencement. As we said, in England, came into force on the 16th of May 2022, and in Wales came in as soon as it was released on the 1st of October 2021. I like what the Welsh have done with their fire safety. They've sat back and listened, and now they've introduced lots of great funding, frameworks and so on to make sure that they can deal with their stock. The issue that they have in Wales is much smaller than ours, but got some really good process and system. Government have also introduced a fire risk assessment prioritisation tool. Now, again, if you're an RTM, an RMC, worth going on the government website, and this is designed to help you understand how dangerous or not your building may be. And you would need to gather certain information. And the information there is detailed on the left of the screen. So you should have, or your managing agent should have, all of that information. I'm not going to read it through, but anything from the height of the building down to the details of any recent fires. You put all that information into the software. Takes about 10 minutes. It's pretty straightforward. We run all of our blocks through this just to see what it says, and it gives you a priority rating. So tier 1 being very high, down to tier 5 very low, and all of the ratings in between. So essential that you use this tool. It's not mandatory, but it would certainly help you prove if you were to have a fire, if there was to be a health and safety incident and issue, it would certainly help prove that you've done the right thing. So if you've got a very dangerous building, tier 1, you take immediate action and advice from a company like us. So again, make sure that you're covered, make sure that you've looked at it in detail. So the Fire Safety Act, in summary, the Act clarifies that the responsible person for multi-occupied residential buildings must manage and reduce the risk of fire. From now on in England and Wales, the responsible person has a legal responsibility to commission a fire risk assessment with these points being considered. And it applies to all multi-occupied residential buildings and is not dependent on the height of the building. It allows the fire and rescue service to enforce against non-compliance. And we've seen lots of issues with the fire service. A lot of our fire engineers are ex-fire service. And we have many meetings with them to look at how the process works and what the issues are on site and how we can make sure that the building is compliant to come up with a sensible solution to allow the building to be occupied. So the way in which we undertake a FRAEW, a fire risk appraisal of the external wall, and that is to a standard called PAS 9980. Sounds very complicated. I'm going to try and simplify it for you now and just give you a little explanation as to what happened and why it happened. We had lots of different formats of reports prior to this being brought in. We had lots of old advice from the government, advice notes 1 to 22, that were then superseded by the consolidated advice note. And it was quite confusing to which ones you had to work to at which time, and some contradicted each other. So the government commissioned through the British Standards Institute a PAS 9980 standard for undertaking the report. And the FRAEW to which the PAS refers to is not within the competence of a typical fire risk assessor. So for all of your blocks, you'll have a fire risk assessment, which is undertaken by a company like Cardinus, Tetra, or so on. And that will refer to if you need an FRAEW or not. So where an FRAEW is considered necessary, the PAS is intended to provide recommendations and guidance. And you have to be qualified to undertake a PAS report. We've actually developed our own software. We were producing reports when it first came out in 16 weeks. We're now producing reports in about 4 weeks. So a fantastic change as technology has helped us with it. And it's a risk-based guidance. So we look at the risks of all of the different silos of information. So we have to look at each wall type. So if you've got 7 different wall types, we have to consider all of those. And for each silo, you can see on the screen. So fire performance, we have to look at all of those items there, the materials, the cavity barriers, fire stopping, and so on. And for each one of those, we will give it a positive, neutral, or negative risk rating. We then look at the facade configuration, looking at the building height of cladding, location of the cladding, how close it is to a source of ignition, and so on. And again, we'll give them a positive, neutral, or negative rating. And then fire strategy. So occupancy, for example, student occupation comes at a higher risk. And then all of the other items there, such as fire suppression, firefighting facilities, and so on. We take all of that information for each wall type and we then give it those ratings. And we gather it in a tabular format. And then we can work our way through and see if the building is of high, medium, or low risk. So it's quite a straightforward way. Our executive summary explains it quite well. So if you have to explain it as a director of an RTM and you were having a residents meeting, it's quite easy to explain in the format that we use. All of our reports meet all of the government approval. The government funding process has to be undertaken with one of these reports by one of the panel. We would look at the ratings and then reduce risk accordingly, always assuming, first of all, that the risk is high, reducing risk appropriately. So, for example, we'll look at high risk, first of all, plot the fire performance of the materials, then the facade configuration, and then the fire strategy and fire hazard. So making sure that we have it correctly plotted. So how does that work in the real world? You can see there on the top right of the screen, a lovely building that we were doing some reports on. And just to explain, all brick and block work. The render there is directly onto block work, so it's not onto expanded polystyrene or some other form of combustible insulation. However, where the yellow arrows are pointed, you can see that there is some high pressure laminate, some combustible product. High pressure laminate is very combustible Euro class DRE and with some combustible insulation behind it. So if you look at the scale on the bottom, we would therefore assume the risk is high and then reduce risk appropriately. So fire performance of the material still remains in the high category. But then when we look at facade configuration, it's very well protected from fire coming up from above because there is nothing combustible below it, and it's actually set back. So we consider all of those factors and we can reduce the risk accordingly. Then when we look at fire strategy and fire hazards, it's at high level. So for example, there's no chance of a car fire catching that alight. Also, the block is fitted with a sprinkler system, which would then allow any fires internally would be put out very quickly. And the data on that is there have been no fatalities in the UK in a residential building where it is fitted with sprinklers. So so fairly safe, and we are fairly confident that no fire would break out there from the inside to the outside. So in this example, and it does demonstrate that this is a risk-based proportional way of looking at buildings, that there is an ability to be able to leave that cladding on site. So we have said we can leave that there, and the rest of the building is all fairly safe because it's all from inert products. Expected skill sets, the PAS sets out clearly who can do these reports, and not just their qualifications, but also their level of experience. So we really like the way that this is set out, and it will improve the quality of reports. So any questions on that? Vicky, if you could just have a look in the chat, please. Any questions at all about that, please do ask.
Yes, we've got just one question here at the moment, which is asking, is the managing agent always going to be the responsible person, practically speaking?
Managing agent isn't the responsible person. It would be the freeholder or the RTM. So if you've got an RTM, a right to manage company, or a residence management company, the same liability applies. You are the responsible person. You are then delegating your duties to the managing agent, but you are ultimately responsible. If you don't have an RTM and you just had lessees and a freeholder, the freeholder will be the responsible person. And we'll come on to that when we come to the Building Safety Act as well. But the managing agent should be undertaking the duties that are necessary to meet compliance, but it all depends what contract you've put in place for your managing agents. We deal with lots of managing agents. Some are absolutely fantastic. Some are completely lost with what they should be doing, and they don't even have type 1 fire risk assessments, and everything in between. So what we can do is we work alongside most of the UK's MAs to help guide them and show them how to meet compliance.
Okay, great. There's nothing else here at the moment that's come in, so I guess we can move on. If any other questions come in, maybe we'll come to them at the end.
Okay, we'll come to questions next on the Fire Safety England regulations, and these are quite interesting. Caught a lot of people out. So they introduce new duties under the Regulatory Reform Fire Safety Order, includes workplaces and the common parts of all multi-occupied residential buildings. So for example, if you had a block of flats over a coffee shop, the coffee shop would also have to be included in this. They are a requirement in law for the responsible persons of high-rise blocks of flats to provide information to the fire and safety rescue services. They do apply to other, not just high-rise, high-risk buildings. They do apply to lower level as well. We'll come on to that in a moment. And to provide residents with fire safety instructions and information on the importance of fire doors. For high-rise, high-risk buildings, which is 18 metres or 7 stories, whichever comes first, it is essential that you have a secure information box. And the idea behind that is it gives the fire service all of the necessary information that is required. Now, we've just looked at a very smart digital system, which I think some of the fire service across the UK, if not all of them, will be adopting. It will be a standard system that is an app-based process with all the information electronically stored, which everyone has got information. So if you put yourself in the position of a commander from the fire service, when they turned up to the fire at Grenfell, the secure information box said that the building was 20 stories high. It was 24 stories. It said that there was a firefighting lift, but it wasn't a proper firefighting lift. There was issues with the power supply and so on. The information contained in there was poor quality. So the idea behind this now is to make sure that all of the correct information is held prior to there being an incident, and it is checked by the fire service, and all of that information is contained in there. Now, when it comes to personal emergency evacuation plans, this is a little bit up in the air at the moment. But first of all, we must look at the statistic of 41% of disabled people who lived at Grenfell Tower perished in the fire. So we must improve on that as an industry. Now, if you're a managing agent or an RMC, RTM, I'd suggest that you survey your occupants once every 3, maybe every 6 months to find out who has a mobility issue. It's still out for consultation. If you look at the bottom box there on the slide in green, the Home Office have consulted on their own alternative measures known as emergency evacuation sharing, and that hopefully will change shortly. However, in your secure information box, I would strongly recommend that you have personal emergency evacuation plans for anyone with a mobility issue, so the fire service can go to that flat straight away should they have to evacuate. There is a health and safety requirement by law that you need to know that information. So key that you look at this in detail. We've just come up with a really smart digital system and the way to make sure everyone has the same information, and that information is up to date all of the time. And it's a really smart process. If you need some help with that, please do let us know. Fire Safety England regulations then do apply to buildings of other heights, not just high rise, high risk, 18 metres or 7 stories. So residential buildings with 2 or more domestic premises with a common area. So they still apply. So let's say you've got a Victorian house, 3 stories converted into flats, they do apply. So all you have to do for that is use the fire risk assessment prioritisation tool. Information to residents on fire safety instructions, so what happens in the event of a fire. Information to residents on the importance of fire doors to a building's fire safety. So if there is a fire, must make sure that fire door is shut, not jammed open, to contain the fire. So fairly basic information. Now, when it comes to buildings of 11 and 17.9 metres in height, you have to undertake 1, 2 and 3, but also have a full fire door survey undertaken. Then for your high rise, high risk, items 1 to 4, plus your secure information box, you must know the design and materials of the external wall. Fairly straightforward. If you think about the Fire Safety Act, you should have undertaken an FRAEW anyway. Floor and building plans, a lot of issues there. We're producing lots of those for customers in a digital format, and hard copies showing the escape routes and so on. Firefighting lifts and equipment, and wayfinding signage. So once we get up to that 18 metres height limit, 7 stories, the requirements are much more. Now, this is mandatory. This isn't advisory. So you must make sure that you are covered, especially if you are a director of an RMC RTM. You are liable to make sure that you are compliant with all of this legislation. Any questions on there, Vicky, at all? It's a very small section.
Yeah, no, we haven't got nothing else come in yet. I can give it a moment to see if anyone submits any questions.
And I mean, you can pop them in at the end of the presentation. If not, and we've got another section on questions. So once we get through the Building Safety Act.
Okay, sure. Yep, we can leave it there for now. Nothing's coming. You can carry on.
Okay, good. So the Building Safety Act. This is the last section with regards to legislation. So you've got to make sure you're compliant with the Fire Safety England regs and the Fire Safety Act, and then also the Building Safety Act. This is the complicated section, so there is lots to it and many facets to it. So I'll do my best to explain it to you and see how you comply or how you think you're going to comply. So the Building Safety Bill was announced in the Queen's Speech in December 2019, and it came into full force in England on the 28th of April 2023. And the more rigorous regime set out in the Act applies to residential buildings of 7 stories or 18 metres, so whichever comes first. So some of the clever developers that have built their buildings at 17.93 but are still 7 stories, these buildings are caught within this legislation. And it applies throughout the life cycle of new buildings and the occupation stage to existing buildings in scope. So as a business, we are very busy making sure new builds comply during the construction phase. Lots of new builds now starting to come through planning as interest rates reduce. And then existing buildings, a mass of buildings. And the statistic is 13,000 buildings, residential buildings in England over 18 metres or 7 stories. That's quite a key bit of data when we come on to looking at how quickly this process is going to happen. The principal accountable person, so that is either the directors of the RTM or RMC or the freeholder, depending on your lease, will be required to obtain a building assessment certificate in a similar process for new builds. There will be a staged transition period, and the building safety regulator will take into account the information available to the accountable person. So if you are an RMC, this is really key to you. Quick look at the timelines. So registration for high-risk buildings opened on the 6th of April 23, and the Building Safety Act, as we said, came into full force 23rd of April 23. As of October 23, it is now a criminal offence to have not registered your high-rise building. Commencement of duties to manage the building safety risk, golden thread of information and safety case reports. And local authority and building control organisations must have registered with the building safety regulator in order to perform the building control work in England. So all moving over to the building safety regulator. So April 24, the building safety regulator commences the safety case process. So they will now start calling in for tranche 1 buildings of very high risk in height, looking at the safety cases. However, we have recently been told that the building safety regulator, if a complaint has been made on the government portal about fire safety or the freeholder or the RMC not progressing the issues of the building quickly, those cases will also be called. So you could be in tranche 4, but if there are complaints, your safety case will be requested immediately. Now, we're in a little bit of a honeymoon period at the moment, and the building safety regulator is working with everyone, making sure that they've got all the information. And this is really complicated to comply with this. Under the new regulations, the principal accountable person must have registered their buildings with the regulator between 6th of April and the 1st of October 23. After this date, the principal accountable person is committing an offence. So as of the 27th of July, between 12,500 and 13,000 registrations were estimated, and pretty much most have been registered. We're seeing a few stragglers that where the height is borderline, depending on how you measure the building, that are just coming out of the woodwork, but most buildings are registered. And this is the information that you need. So you can see that the production of some of this information may be an issue. So initially you had to put in your key building information, the items in green there across the bottom of the screen. Then to produce your safety case, all those items in yellow, you need all of that information. And that feeds into the building safety case and produces the golden thread of information. We'll talk about the golden thread on the next slide. But as if you can imagine a golden thread running through all of that information, pulling out the key elements to enable that the building is managed and all of those works are undertaken correctly. That feeds into a safety case report, goes to the building safety regulator for the building assessment certificate. So lots of information that needs to be gathered. It is quite a process to gather that information. So if we think about Grenfell, trying to get the information from everyone is very difficult. Now, it's not just Grenfell. We do lots and lots of surveys, FRAEWs on buildings, and we try and get hold of the information of what type of cladding it is, what type of fire doors you've got there, all sorts of information that is really useful, and it's very, very difficult to get that. So the intention of the golden thread is to ensure that the right people have the right information at the right time, to ensure the buildings are safe and building safety risks are managed throughout the building's life cycle. So it's key that we get all of that information. And with regards to safety cases and the safety case report, so if you consider there are 13,000 buildings that this applies to and put yourself into the building safety regulator's position, a safety case is a structured argument supported by evidence intended to justify that a system is acceptably safe for a specific application in a specific operating environment. A safety case should provide all information used to manage the building's risk of fire spread and structural safety of the building. So it's not just limited to fire. We look at lots of buildings that have got issues with concrete movement, some form of structural defect. So we have to consider that as well. Now, a safety case report is a document that summarizes the safety case to identify the building's major fire and structural hazards. So put yourself in the building safety regulator's position. They can't read a 600-page report with all of the information on 13,000 buildings. They could, but that's a 30-year problem to try and get through all of these buildings. So we have to produce a summary of it, which is the safety case report. There is a new British standard, 8644. All of this process is digital, and therefore there is a new British standard on how to manage that digital information, keeping all that information secure. So quite clearly set out under BS 8644. I could talk to you for a couple of hours about that, but I wouldn't want to send you all to sleep. But there is some key information in the way in which you have to manage it. Building safety compliance manager, so you must have someone who is producing that safety case, which has the competencies to understand and work to that. Now, the Chartered Institute of Builders, of which we as a business are chartered with, all of our building safety managers are CIOB level 6 diploma in building safety management. But key, we'll come on to competencies in a minute, but key that they have that experience and the qualification. The role is pivotal to undertaking the tasks required to prepare the building safety case report. And the role is designed to answer two fundamental questions. Can the building safety risk be identified clearly and efficiently in the building? And could evidence be shown for how these risks are managed on an ongoing basis as far as reasonably practicable, so the building is deemed safe? So looking at all of those risks throughout. Now, the process that we work to is, first of all, analysing the information that's available and the quality of that information to make sure that we can produce the safety case. We'll then look at what information's missing and price for that to give everyone the cost to undertake that. And then we'll produce the residents' engagement strategy, and that's quite key on how you're going to engage with the residents about all of these safety issues. Is it through a website? Is it through a digital notice board? Is it through emails? Is it just through the concierge, and so on? Then we must produce a template for a mandatory occurrence report. And again, all of this is checked by the building safety regulator. A mandatory occurrence being something like if there was a fire at the property, what happened with that fire? How far did it spread? How quickly was it put out? Did it cause an issue internally or externally? Did smoke spread up 7 stories? The fire over in East London about 2 years ago, fire spread up 2 stories, but the smoke spread, I think it was 18 stories internally due to poor compartmentation. Preparation and submission of the safety case report, and then creation of a website, doing lots of those at the moment to make sure that we clearly engage with the residents. Really good way of doing it because it gets around all of the language barrier issues, all of the translation, and is really quite clear for tenants as well as lessees. Further consultancy where required. So there's always an issue with other elements that need to be addressed, and look at those and how we communicate those across. And then the annual management and review of the building safety case. So making sure it's not just produce a safety case and forget about it. You've got to produce the safety case, and then you have got to look at how you're going to manage that. How are you going to make sure your automated opening events are serviced every 6 months or every year, depending on the manufacturer. All of those issues, and then we're doing lots at the moment to make sure that when it's checked each time, the building is safe and compliant. So the building safety regulator is an amendment to the Levelling Up and Regeneration Bill passed in late June, gave the government power to replace the HSE in this role. So the building safety regulator sits on their own. They're not overseen by the HSE, as was going to be the original process. The building safety regulator is working closely with local authorities and fire and rescue services, and bringing in external technical experts as necessary. So they are key in this process. Now, to help understand what the requirements are for each person, body, etc., the process, the Building Safety Act, has introduced PAS standards, publicly available standards for each area of competence. So PAS 8671, the competence of the individual principal designers. So who is responsible for the project, for the building? The principal designer. They now have to comply with PAS 8671. So it can't just be a firm of architects that haven't got the experience or the qualifications. And that has been key to when we look at the issues at Grenfell, why they occurred, that the team simply didn't have the right experience or qualifications to be able to manage a complicated construction project. And when it comes to contractors now, if you're working on a high-rise, high-risk building, you must comply with PAS 8672. So you've got to make sure that they are, again, correctly experienced and qualified in working on high-rise, high-risk buildings. That is causing a bit of an issue to the sector, that now there are less contractors available to do the work, which means the work will be undertaken over a longer period. But the good thing is it will be undertaken properly because they will comply with PAS 8672. So we as a consultant have to check all of those competencies and make sure that they are compliant even before we send them a tender. So we go through quite a diligent process with regards to that. So PAS 8673 is the code of practice for the accountable persons and others in managing building safety risks. So to make sure that the principal accountable person fully understands what their requirements are, what their consultants should have, the correct qualifications and competency. So all very clearly set out. Lots of managing agents, lots of RMCs have been going through these in detail to make sure that they're covered. So if we look at roles and responsibilities, the building safety regulator, they are leading and implementing this new process. There is a national regulator for construction products. Lots of issues at Grenfell with products, the installation, Celotex, fabricated the test rig so that their installation passed. Kingspan, allegedly took 90% of the flame retardant out of their insulation and then sold it as the same product. That will all come out as we hear the conclusions of the phase 2 of the hearing shortly, hopefully. So there is now a national regulator for construction products. The principal accountable person could be an individual, partnership or corporate body, depending on the lease. Normally, though, if there is an RTM, RMC, you would be the principal accountable person if you are a director of that business. If there isn't an RMC or RTM, just a freeholder, it is normally they would normally become the principal accountable person. You will need a building safety manager to the correct qualifications to make sure that that the process is undertaken to the correct competencies, to the correct standards. And now there are duty holders. So for every element of this, under the Building Safety Act, there are clear duty holders which have the roles and responsibilities. So Lakanal House, a fire in 2009, 6 people were killed. No one was prosecuted for that fire because they couldn't pin the blame onto any individual corporate company, individual. It was too complicated. That will not happen again. Every part of the construction process and management process has clear roles and responsibilities. So residents have new rights to receive information about the fire safety of their buildings and so on. Golden thread of information, which is a key requirement of the Building Safety Act, to make sure that you've got all of the right information in the correct readable format to the right people held digitally, and access to health and safety information. Your managing agent must make sure that they have all of the correct health and safety information accessible to all at the right time. Now, to give everyone a bit of confidence when we're undertaking construction works, we undertake a lot on blocks of flats where there are major issues. We work closely with the Building Safety Fund, the Cladding Safety Scheme, and with developers. There are some really good developers out there that are doing a great job of remediating their buildings. There are some out there that aren't doing a great job, and it's quite key that we make sure the works are undertaken correctly. However, there are some delays to the construction process. So if you have a major change on the site, a variation of the works, the change must be notified to the building safety regulator, and the works have to stop on that for 6 weeks. So again, these construction projects are now going to take longer with these major changes. And then if there are notifiable changes, they still have to be notified to the building safety regulator. So when the project is finished, something has changed from the original design. It is key that all of that information is gathered. Why did it change? Why did the product change? So there's lots of issues on buildings across the UK where the product that was meant to be used hasn't been used because perhaps the quantity surveyor has got hold of the specification, found a cheaper product, replaced that, but hasn't considered the fire risk, the combustibility of that. Now, this is how the process will look. We have the building safety regulator at the top of the tree. We then have underneath that the principal accountable person. We have the building safety manager answering into the PAP, the accountable persons. So there may be accountable persons. For example, a good example of that is fire doors to the front of apartments. All of the lessees, if they're demised to those properties, are accountable persons. Then you'd have the principal contractor undertaking those works, which has got to comply with the correct PAS, and then the principal designer, who is ultimately responsible for the health and safety of any construction work. Then below all of that is the team of consultants that you would need. And that's where we found that there was a problem in the industry, that there were lots of different consultants out there, but there wasn't one company that pieced them all together. So we act as the principal designer and all of those consultants, all held under one roof. Lots of leaseholder protections, and I'm sure that many of you have heard that lessees were receiving very large bills for these remediation works which was completely unreasonable, where they weren't the people that had caused the issue. So some good leaseholder protections came in on the 28th of June. Building Safety Act commenced new statutory protections for qualifying leaseholders in England against remediation of historical building safety defects, and that they cannot be charged to the lessees. We'll come on to that in a little bit more detail in a moment. There is the necessity since July 2022 under the leaseholder protections under the Building Safety Act to produce a leaseholder certificate, which provides a permanent record as to how the flats were owned and occupied on the 14th of February 2022, and evidence that the flat is a qualifying lease. So lots of text on there. I'll leave that for you to read through. However, a leasehold certificate will help protect all of the lessees within the building, and also a landlord certificate acts as the permanent record to the status of the lease, contains information which is needed to calculate how much the landlord is entitled to charge for building safety works. And when we think how much they can charge, so if you've got a property outside of London, it is £10,000 limit over a 10-year period. Inside London, it is a £15,000 limit over a 10-year period. So really key that these landlord certificates were accurate. And when they first came in, there were lots of managing agents gathering all of that data, how much had been spent previously, how much could be billed correctly. Now, lots of reports that are needed, as we saw on the Building Safety Act slide with the yellow elements of work that need to be provided. Now, those reports are all chargeable to the service charge. We took some advice from Blake Morgan. Where does the cost sit? The idea of the Building Safety Act is that any costs for building works that are not due to defective works that are non-compliant with building regulations, which mean the building is unsafe, are not chargeable to the lessees. But the cost of all the reports, reduction of the information is under the service charge. So that's a question that we get asked an awful lot. Further leaseholder protection. So all remediation works fall under a waterfall payment structure, and these protections operate right the way through for works which are of a fire safety life critical defect. So your first port of call will be to go to the developer and under the developer pledge contract, claim from them that they need to rectify the works. Now, we're working with some great developers. Red Row doing a fantastic job on some of the blocks that we're working with them, rectifying all the works externally and internally, and just getting on with it. So we're working with some other developers on behalf of freeholders that are taking a very long time to deal with their issues in the correct and to the correct standard. So building owners would be your next port of call. So if you don't have a developer, for example, the developer's gone out of business, you would then go to the building owner, which is the freeholder. However, if all owners within a group net worth of over 2 million per relevant building they own will have to pay for these works. A lot of freeholds don't hit that threshold. We haven't seen any yet where the building owner has had to pay for them. And as we said, the only amount that can be charged to lessees is £10,000 outside of London and £15,000 inside of London. So that causes an issue. If you don't have a developer, if you don't have a building owner that is required to pay for the works because they don't hit the £2 million cap, then the leaseholders only have to pay £10,000 or £15,000 depending on location. And that is when you would make your application to the correct funding route. And we deal with all of these. So first of all, you had the £1 billion fund, which is now closed, which was completely exhausted, around about 1.258 billion. Then we had the £4.5 billion fund, building safety fund, for buildings over 18 metres, which was a good fund. It only covers external works. It doesn't cover anything internal, so fire doors, compartmentation. The cladding safety scheme was then announced for buildings of 11 to 18 metres. There's been some key changes in that. It's now for buildings 11 to 18 and then 18 and above. And we're seeing a lot of cases being transferred from the Building Safety Fund into the cladding safety scheme. So we've probably got about 140 odd blocks in total going through the CSS. Good scheme. A lot quicker than the Building Safety Fund, learned from the issues with the process, and we work very closely with MHCLG giving advice and to Homes England on where the issues, the bottlenecks, the problems are. So that CSS scheme is quite a smart way of getting your remedial works covered. However, it doesn't cover internal compartmentation. The developer pledge, the developers signed the pledge on the 13th of March 2023. However, we are seeing quite a few issues there. For example, developers not having undertaken an FRAEW, which is necessary for that pledge contract to know what works need to be rectified, taking over 12 months to get those reports. And then warranties. So if you have an NHBC type warranty on your building, we've had some fantastic results with warranty providers to get them to pay for all of the works. Now, we may well progress with the developer pledge and trying to get the developer to pay for it, but we also run in tandem the claim with the warranty provider. We may well do the same with the cladding safety scheme, carry on with the cladding safety scheme, and then still trying to progress the warranty provider to pay for it. So we've had some really interesting, really good results, and the key element is keeping all of the costs away from the service charge and also getting the polluter to pay for it. So if it's been built wrong, why should the lessees or the RMC RTM have to pay for it? Cladding safety scheme, as I said, great system for getting costs covered, but doesn't cover internal works. We are pushing to get the scope changed, and my opinion on that is that the works will open up with regards to looking at the internal compartmentation for the Building Safety Act. So I think we'll find more and more issues with internal works as there are external works. Southern Ireland, they've got some funding for interim measures. Northern Ireland, they use the CSS. Scotland, just getting their process sorted with the single building assessment. So we're doing a fair bit of work there. And in Wales, they've got a really good framework called Chic and a really good funding process to cover works for 11 metres and above. To work on the CSS, assessors panel, you have to go through a process of being checked. We are one of those FRAEW reporters, and the FRAEW assurance assessment, all fire risk appraisals of external wall reports are submitted and audited. So all reports that go in are checked to make sure they're compliant. Now, this one is probably of very much interest to you, especially if you're an RMC RTM. Remediation contribution order. So if, let's say, for example, you had a developer and they said, no, we're not doing any work on the building, or we're only doing very minimal work. You had a report from us, let's say, that says lots needs to be done. Your process would be under the Building Safety Act to apply to the first tier tribunal to get a remediation contribution order. And each first tier tribunal now has a expert, facade and fire safety expert on that panel to decide who should be paying for what works. Is the scope right or not? So great part of the process. Another element that's been brought in is the building liability orders, where you are engaging with the developer. This is a much harder way to get the developer to pay. It's a much slower process. You have to go to the High Court for any defects for the fire spread and structural failure. The fees are much more. So I would normally guide people to going for an RCO, remediation contribution order. There will be some building liability orders working their way through the courts. Some interesting data on warranty claims. So the Building Safety Act amended the limitation period in which a claimant could raise a claim under the Defective Premises Act from 6 years after completion of the property to 30 years, which has meant that warranty providers' terms have also had to change. So if you do have a warranty and you think that was out of date, worth checking with us if we think you can still claim on that warranty. So project compliant process with the developer remediation, essential that you get a fire risk appraisal of the external wall. Must make sure we know the exact height of the building, and then also look at internally under a type 4 fire risk assessment, which is an intrusive investigation of the compartmentation. We also then take all of that data and produce a report that says where it is in breach of the building regulations. So the building regulations are very key to show that the works didn't comply with the regulations at the time of build. Hence, that will trigger your claim with the developer under an RCO building liability order, but also trigger your warranty claim. There are 3 gateways now that we have to comply with within the Building Safety Act, one at cladding stage, one at before the work start, and one when the building work is completed. So the one without planning, we have to submit a fire statement with that, so a fire strategy basically with the planning permission. So it's thought about exactly how you're going to build it and from what materials and so on. But Gateway 2 requires the full design of the project to be undertaken and submitted. And this is where the delays are coming, currently taking 19 weeks for the building safety regulators to sign those off, which is a completely new process, but really good because you're showing on there all of the materials and process and construction details that are to be constructed. Then Gateway 3, you have to prove that you've built it to get those to those standards. And then you will get a completion certificate and not before. The completion certificate process, I think, is going to take about 6 to 8 weeks. So again, adding time onto these projects, but it is showing the materials that should have been used have been used and it has been signed off. So when you get that completion certificate, it will be meaningful. Unlike a building reg certificate, which is only an indication of compliance. Legally, you cannot confirm that all those works have been undertaken to the building regulations. A much better process. High-risk building regulations 23, some clear and concise guidance here as to what is a high-rise, high-risk building. So of at least 18 metres in height or has 7 stories, whichever comes first, with a minimum of 2 residential buildings. So if you had an office block with 2 flats on the top and it's over 18 metres, the whole of that building comes under the Building Safety Act. So the Building Safety Act, in summary, I appreciate that we are tight for time, does apply to new build and existing buildings. So you must register your building, produce all of that golden thread of information, make sure that the safety case and the safety case report is completed to the correct standard, get your building assessment certificate and approval for occupation, and then annual management of that moving forward. So really key that all of those criteria are met. Now, I really appreciate I could talk to you all day about just the Building Safety Act and all of those other elements. Construction and residential buildings haven't been governed by any regulations. Even Michael Gove admitted that our regulations weren't fit for purpose. Now we have a 400+ page document with the Building Safety Act and all its appendices that govern how we will manage the construction process and residential buildings moving forward. Any questions on there at all, Vicky?
Yes, we do. We've got a couple we'll try and get through quickly. So the first one is from Carly. It says, can you still go to the developer to fully fund remediation of a relevant defect, even if they haven't signed the developer's pledge, if they are still trading? Is the freeholder then exempt from any contribution? And then she said separately, the freeholder is not associated with the developer.
Right, okay, so they're 2 completely separate entities. Yes, they don't have to be a pledged developer to have to pay for it. So I would still be going after them under a remediation contribution order saying, look, we've got these works, but what you would have to prove is that they hadn't been undertaken in accordance with building regulations. So you might have your FRAEW, that is looking at risk of the building. We then upgrade that to tell you where the breaches were in building regs at the time of construction. We accompany it with that with hundreds of photos, video footage of that, so they can't argue it. Then we'd meet with the developer and say, look, if you're not going to pay for it, we're going to progress down the remediation contribution order. There's a couple of developers out there, which I'm really pleased to say aren't pledged. They didn't meet and the way that you become pledged is if you make 10 million or more EBIT, earnings before interest and taxation. And they're not pledged, but they're still getting on with the work. They're still working with people to try and get through these, so to make sure that the building safety is required. Now, we must remember a key bit of information for you. Under the 1984 Building Act, not the Building Safety Act, the Building Act, that is when it became mandatory to work to building regulations. So if they're pledged or not, they've still got to work under the 84 Building Act to make sure that they have constructed the works properly from the right materials and to a workmanlike standard. So yeah, good question, really good question. We can help you with all of that if you're struggling.
Okay, one more we'll quickly try and get through. Would you consider a basement which has a separate egress to the rest of the building and shares no access with the wider building to be an independent section?
That would fall under the same part of the building. Now, I thought you were going to ask about how you would measure the height if you've got a property in there. Yes, we'd have to look at that individual case. It depends. If you've got a little light well, we'd ignore that. But if you've actually got a terrace, that becomes the lower ground floor and how we'd measure it. But it's all part of the same building under the Fire Safety Act, Fire Safety England regs, and the Building Safety Act.
Okay, I think that's it. So I think we can finish up there. If anyone does have any other questions, obviously, please feel free to send them through to me, or I can pass them on to Dorian, or you can contact him directly.
I'll just skip forward to just these slides will just give you the services. So basically, we'll undertake any element of reporting, lead consultancy work, gathering the information, and the Building Safety Act. We will work through all of that information by all of our employed staff, so whatever is needed to meet the requirements. So complete projects, we finished lots of towers on the banks of the Thames, in East London, up to Leicester, Middlesbrough, Liverpool, Manchester, all sorts of different residential buildings, all high-rise, high risk, though, different types of products and so on, doing the complete role and now doing the building safety case. So quite an interesting process. But if you could leave us a Google review, if you scan that QR code, that would be fantastic for us. If you've got any issues, problems, concerns, developers not doing what they should do, or doing what they should do, but you need someone to check it. We're doing lots of work for freeholders who need some assistance to make sure work's compliant when they're doing them on site. Lots of projects with the Cladding Safety Scheme and the Building Safety Fund, and even some warranty projects nearing completion. We've tracked all that legislation from day one. We can make sure that you are completely compliant. It's quite a minefield, especially for RTMs and RMCs that have perhaps got directors that need some assistance trying to unravel all of this legislation. It is complicated. Hopefully, I've tried to simplify it for you and you've understood a fair chunk of it. But if you've got any queries, just drop us an email. We'll come back to you in 24 hours or so. So thank you for listening.
No worries. Thank you, Dorian, for your time. I will arrange for a copy of the slides to be sent out. So all of this contact information will also be on there for anyone that would like to get in touch with Dorian. Yeah, thank you very much for joining us. Thank you again, Dorian, for your time. And I'll see you on the next one.
Excellent. Thanks, everyone.
Have a good rest of your day.
Thanks. Bye.
Bye.